All right. Good morning, everyone. Can everybody hear me?
We can, Your Honor.
Excellent. Excellent. Good morning and welcome to the 5th District Court of Appeal. On behalf of myself, Judge Eisnagel, and Judge McIver. We have one case this morning for oral argument. It's case number 21-3189, and that is Department of Agriculture and Consumer Services versus the Mahans. Did I say that correctly?
It's the Mahans.
The Mahans. Okay. Thank you so much. All right. And I would just ask everyone, if they haven't already done so, to go ahead and silence all your electronic devices. And counsel, how much time will you be reserving for rebuttal today?
5 minutes, Your Honor.
Okay. And I will do my best to help you keep track of that. But at the end of the day, it's your responsibility, but I'll try to help you out. Okay.
Yes, thank you.
All right. And with that, I believe we are ready to begin.
May it please the court, my name is Wes Parsons. I'm the attorney for the Florida Department of Agriculture. This case is about the Florida legislature's reaction to the crisis in citrus agriculture that began more than 20 years ago. Diseases of citrus, citrus canker, and citrus greening swept through Florida from south to north. The citrus canker eradication program, which was intended to stop citrus canker in Florida, did not succeed. Citrus greening, and even more serious disease of citrus.
Counsel, there's a part of your brief that I'm not sure I fully understand after review. Maybe you can shed some light on it. Your brief, I believe, it seems to indicate that the trial court erred. One of your arguments seems to be that the trial court erred in thinking that there's a difference between a written order and a verbal order. And that's not at all how I read the trial court's order. So I was hoping that maybe you could clarify what you were arguing on that point. And if you maintain that argument, maybe I misread it.
I do maintain that argument, Your Honor. There were a series of 3 orders. The first 2 were in writing. They were called stop, sale, and hold orders.
Well, we're familiar with the record, counsel. I'm more interested in why do you think that the trial court thought that there's a substantive, that this case is decided by the fact that one set of orders were written and then another order was verbal?
I think that because the trial court ran through the 3 Penn Central factors for the written orders and found in the Department of Agriculture's favor. It then ran through the 3 Penn Central factors for the verbal order, and without, in my view, any logical reasoning, found that the verbal orders all cut the other way, except for the last one, which was more of a tie. But there was no distinction between a written order and a verbal order as to each of the Penn Central factors. You really kind of need to dig into the factors to see this. The first Penn Central factor is the economic effect on the property owner. The economic effect, in our view, was 0 because the property owner simply could have complied.
I mean, when I read the trial court's order, I feel like maybe you're misreading. One of us is misreading, either you are or I am. And I'll give you a chance to disabuse me of my reading. But when I read the trial court's order, it sounds to me like the trial court was essentially saying, hey, look, in the written orders, there was no requirement that anybody destroy citrus trees. Okay. However, the trial court said the undisputed evidence on the verbal order leads to a different conclusion, that it inevitably was a requirement to destroy the trees. That is how I read the trial court's order, distinguishing between the two. Tell me why that's wrong.
It's wrong in the second part, Your Honor. There was no finding and there was no evidence that the inspector told Mr. Mahan he had to destroy those remaining trees.
No, that's right. No, there was no evidence he expressly said you must burn these trees. That's correct. The trial court instead said, essentially, based on what the undisputed evidence of the verbal orders was, there was nothing left to do. That there was literally nothing else that they could have done. They were being told undisputedly that they had to do something, but they couldn't move them, they couldn't sell them, they couldn't plant them. And so the trial court said, look, at the end of the day, that was an actual, even though implicit, an order that they had to destroy them in some way. But regardless of whether the trial court was correct about that analysis, the trial court did not make an analysis of, well, if there's a written order, it's one way. If there's a verbal order, it's another.
Well, in either case, either under the written orders or the verbal order, the Mahans options had drastically narrowed after January 1, 2008. Before that deadline, they could have enclosed their citrus, as all the other citrus growers except one did, or they could have sold their citrus, or they could have left the industry. They had lots of options. Options is a key under the Galaxy Fireworks test. After January 1, 2008, the options drastically narrowed. The Mahans could sell their citrus in Canada. There was disputed evidence that they could have planted a grove on their own property, and that's about it. There was no economically viable other option available to them. That's a consequence of the Mahans' own actions, and that's the way the trial court should have analyzed it. There was no difference in the Mahans' remedies as between the written orders and the verbal orders. The outcome at the end was the same. They had contraband. They had a lot of citrus. It was under a stop sale order. It could not be sold in Florida or elsewhere in the United States, and effectively, they had to do something with it. That's what the inspector told them. He was correct. After January 1, 2008, you could not sell that citrus. You could not enclose that citrus. Both things were illegal. Effectively, something had to be done with it, though, and the Mahans did what was probably their only option other than a sale to Canada, which was to destroy the citrus. Your Honor, if we can kind of go through the Penn Central factors, that might
Yeah,
be
counsel, I think that's your better argument than the trial court thought verbal orders were not okay, but written orders were.
So in Penn Central, there's three factors. The first factor is the economic effect on the property owner. In this case, the effect is zero, simply because the Mahans could have enclosed their citrus or could have sold their citrus, as every other citrus owner except one did. That should have cut completely in favor of the Department of Agriculture, but it did not, as to the 7,700 citrus plants. That's the logic this court followed in the Orlando Bar Group case, which itself depended on the Galaxy Fireworks case.
Counsel, I think one important issue here is our standard of review, not really addressed in any of the briefs, not thoroughly anyway. And as far as the trial courts, not our review of historical facts, obviously, that's probably a relatively easy one. But once the trial courts establish the historical facts, then what is our standard of review for the trial court's application of those historical facts to its conclusions on the Penn Central factors?
It's completely de novo. You can see that from the three cases we mainly rely upon: Orlando Bar Group, Save Working Animals, and Galaxy Fireworks. There's very little, perhaps no, difference in the parties' views of the fact finding by the trial judge. We accept the fact finding. We simply say that trial court got off on the wrong foot in the analysis of the Penn Central factors, overlooking the three main points.
I'm not entirely sure Orlando Bar Group clearly gets us there. I mean, we affirmed in that case, and we did not, I don't remember seeing a discussion of the standard of review. Essentially, we agreed with the trial court's conclusion in that case, correct? We didn't reverse it.
Yes, Your Honor. There's surprisingly little discussion of the standard of review as to fact finding in eminent domain cases under Penn Central. The general sentiment seems to be that the court can be pretty relaxed in its analysis. You see that again and again when there are reversals, and even in some affirmances. And the court says, we are going to apply Penn Central. This is the way it's going to be in this case, and they run through the three factors. So,
well, and I think that often, oftentimes that they're in constitutional type issues, we do see a de novo review in certain circumstances. However, that said, I'm not sure it's always that way. And I think in this case, when you're asking us to reverse the trial court, when we reverse the trial court's findings on the three factors, the standard of review might become important.
Your Honor, I can say this. I don't think it's important in this case because we do not disagree with the trial court's fact finding. We agree
Do
with.
you disagree with the trial court's finding that all three factors favor the appellee?
Well, that's of course a legal analysis, Your Honor, and we very
Well,
much.
but that's counsel.
disagree
That's what
with
I'm
it.
saying. I'm not sure it's of course a legal analysis. I'm asking you, is it a de novo analysis, or is there some other standard here that we have to adhere to when reviewing the trial court's conclusions based on the historic facts? Right.
It's
Historic.
a de
You know what I
novo-
mean by historic fact? Historic fact is, hey, look, they had, however much time it was, 18 months to comply, and they just didn't. That's a historic fact, right? But then the trial court's conclusion on the three factors, not a historical fact.
I would
Right.
say it's the application of the law to the facts, what every trial judge does. And the application of the law was incorrect because the judge basically ignored the principal fact under every factor. It wasn't a case of disagreeing with the judge. He simply disregarded, in most cases, in all three factors, the main fact. He disregarded the phase-in period. He disregarded the extremely heavy regulation of citrus agriculture in Florida, and he tended to disregard the compelling need for this public policy to be imposed on Florida Florida nurseries to save the nursery industry. It's simply legal analysis. It's de novo, Your Honor. That's our view.
Do you think the trial court, and as I read your brief, oftentimes it felt like you were arguing that, hey, look, the trial court did not understand the three factors. And in other words, the trial court's analysis, the trial court essentially modified some of the factors, or maybe all three. And again, I think I'm trying to interpret your initial brief. I felt like you were saying, look, the trial court misunderstood the factors. And that's why the analysis is off in essence. Is that your argument then on appeal, or at least one of them?
The trial court misunderstood and misapplied the three factors. Absolutely, Your Honor. And it wasn't in a small way. It was in, as to each factor, the, most important, significant, indicator was missed by the trial court. I'd be happy to talk about any of the three factors. If we can go on to factor two, the reasonable expectations of the Mahans in a heavily regulated industry such as citrus agriculture, regulated by not just one agency, but two separate agencies of the Florida government with reams of statutes and reams of regulations. In that situation, a property owner has to know that there may be changes in regulations. A historic fact in this case was the presence of citrus canker and citrus greening in Florida. Everyone in the industry had watched the fight against those for years. Many of them had lost trees to the citrus canker eradication program, which began in 1995. It can no way be considered a surprise to these property owners that there was a change in the regulation to try to preserve the citrus industry by making sure that clean, disease-free trees came out of the nurseries. Every citrus tree in Florida comes out of a nursery. Wild citrus trees are extremely rare. So one way to preserve the industry, the way that the legislature selected, was to ensure that the trees that are being sold out of the nurseries would be disease-free. And that requirement came into effect on January 1, 2008. Every nursery owner except Mr. Mahan and Mr. Mahan's brother were able to substantially comply. And as a result of that, we have a better citrus industry, a stronger citrus industry today.
You argued that the trial court missed the mark on the third factor as well. Can you maybe address that briefly?
Sure. A lot of these factors tend to blend together, but the third factor would be the government's interest in a citrus industry. And the cases are legion that the citrus industry is a matter of great importance to the Florida legislature. Under the legislature's police power, they are allowed to regulate the industry. They have been doing so for 100 years since citrus canker first appeared in Florida. It is one of the strongest public policies you might say there is in Florida to preserve one of our two signature industries.
But how did the trial court misapply, in your view, that factor?
Well, it was the least of all three because it found in our favor as to the written orders and found it was a close call as to the verbal order. But of course, it kind of goes back to what was the trial court thinking in terms of a distinction between the two types of order. If the legislature has this ability, the power to impose this public policy, why would it be any different as between a written order and a verbal order? It simply it isn't logical to divide up the orders in that fashion. The verbal order itself, perhaps we ought to go back to that for a moment. The verbal order was an inspector who came out after the Mahans had destroyed the trees under the written order and told Mr. Mahan, you have to come into compliance with the statute. This is already the law. Mr. Mahan said, well, can I sell the trees? No, that's against the law. Mr. Mahan said, well, can I put the trees in a structure? No, you missed the deadline. That's against the law. Well, what can I do with the trees? And the inspector said, well, you need to do something with them, which again is a pretty good advice. In any case, no written order was ever issued. I'm sure it would have been in the pipeline eventually if Mr. Mahan had continued to be intransigent. But the point is, the law already existed as of January 1, 2008, because of the legislature's pronouncement. And the law required compliance, and Mr. Mahan was out of compliance every day after January 1, 2008.
And counsel, I'll just let you know that you're into your rebuttal time.
Thank you very much, and I do reserve. Thank you.
Okay, we'll reserve. It looked like it was 4:17. All right. Counsel, go ahead.
Good morning, and may it please the court, Attorney Ryan Reese with the law firm of Moore, Bowman and Reese for the appellees, John and Shelby Mahan. The court will notice the 2011 date attached to the lower court case number. This taking saga, much like the citrus litigation preceding it, over the past 3 to 4 decades, has been relentlessly litigated by the department.
Counsel, what's the economic impact when your client had, how long, 18 months? All they had to do was move their stock into a screen house, or, I've seen and the record has various different names for it. I'll just call it a screen house if that's okay. Your client had, 18 months to do that. And if they had done that, there's no economic impact at all in the sense that they don't have to destroy a single tree, right?
That's correct, Your Honor, but that's using the very regulation that the Mahans challenged as the reason for why their claim failed. That's circular reason.
Correct. The way the regulation is written, it permits your client 18 months to simply move the trees. So what's the impact? What's the impact of the regulation?
Well, the impact on the regulation is that it
No. The impact, the economic impact of the regulation.
The economic impact of the regulation was that, but for that regulation, the Mahans would have commercially valuable citrus.
How about but for your client not moving the trees into a screen house as the law required and having 18 months to do it?
And I understand that argument, and that's been the argument of the department throughout this entire case, but the actions of the property owner are not material to a Penn Central analysis.
Are they not?
Really? They're categorically not.
Okay. Counsel, there's no amount of time that the legislature essentially is not permitted to require trees to be moved into a screen room, or if they do, the owner is permitted to ignore the law until the time expires and then force the state to pay for it.
Well, the state is absolutely allowed to enact police power regulations that regulate property. And here, the focus of any Penn Central case, Penn Central analysis, is the burden of that regulation on the property owner.
But exactly. So why is it exactly? That's exactly right. So in this case, the statute didn't say, hey, everybody, as of yesterday, burn your trees and start over. It said, hey, everyone, you have 18 months to move your trees into a screen. That's the impact of the regulation. correct?
I would disagree. I mean, there's no burden on a property owner to, quote, mitigate his damages. I mean, mitigation of damages is a creature of tort law. And that's a theory that the department argued throughout this case. There's not a takings case
No,
out there.
that's the problem. I'm not talking about mitigation of damages. I'm saying, look, the regulation doesn't require destruction of citrus trees. It only requires destruction of citrus trees for someone who ignores it for 18 months and doesn't move the trees into a screen room.
Well, I would contend that the Mahons, it's factually disputed whether the Mahons, quote, ignored the regulation. I mean, the trial court's order is very clear that they were
Did they move the trees into the screen room?
They attempted to move some of the trees into the screen enclosure at the beginning of January.
So how is it disputed? I mean, they didn't move them. That's undisputed. It's undisputed that the regulation was passed and they had 18 months to do it, correct?
That's correct.
So what is the dispute then?
That they were given misinformation about whether they even could. I mean, the trial court found in its order that they were told at the onset by the department representatives, in fact, the chief inspector, Jim Holm of their nursery, that they at the onset couldn't do anything with the citrus, that it was basically commercially worthless.
What when you say the onset, what date is that? Give me a date.
Oh, it's in the record, Your Honor. I don't have
Well,
an
give
exact
me a
date.
rough date. We talking about 2007 or 2008?
It would have been after the regulation was passed and it became effective in 2007.
Would it have been after the deadline or before the deadline to move everything in?
Before the deadline to move all this, before the January 1, 2008 deadline to move all the citrus into an enclosed structure. I mean, they were told from the onset, and the part of the problem I think the trial court had was the only testimony on this issue came from Mr. and Mrs. Mahon. The department's inspector that gave this information didn't testify at trial. So the uncontroverted evidence was that at the onset, after the regulation became effective in January 1, 2007, was that the Mahon, you had to move the citrus, you had to get rid of the citrus altogether. And then over the course of that year, around December, Mr. Mahon became apprised of the fact that he could actually move the citrus into a screen enclosed structure and be exempt or be protected under the regulations. And they had a month at that point to try and comply. The record reflects that they did try to comply. In fact, they did move some of the citrus into a structure. They just didn't get it all moved in time for the January 10 stop sale order. But again, I would contend, Your Honor, the actions of the property owner are immaterial under the Penn Central analysis. There's not a takings case out there that says an owner has to mitigate his damages.
No, and again, I didn't use the word mitigate, counsel, and I don't think it's a mitigation issue. I think it's a compliance with the statute issue. So for the moment, setting aside your argument that, hey, look, they were misinformed early on about what the statute required. Now, keeping in mind they could have just looked at the statute. But nevertheless, putting that aside, let's say for a moment that didn't happen. And so we didn't have that complicating factor. Then what is the economic impact when the statute says you have 18 months to simply move the trees or sell them into a screen room and your client simply doesn't?
Well, the economic impact is the fact that the regulation being passed caused the Mahons to have invaluable citrus. I mean, the entire crop was commercially worthless after the January 1.
So in your view, the regulation didn't require them to go to the expense and effort of building a screen room and moving everything into it. In your view, the regulation actually instead required them to lose the citrus.
That's correct. I mean, looking at it as though, but for the regulation, the Mahons had no reason to expend funds to build a screen house. That was a regulation that Mr. and Mrs. Mahon both.
So is the real economic impact here the economic impact of having to build a screen house, and which could be substantial in certain circumstances, and then also in addition to that, the effort of moving all of your stock into those screen houses? Isn't that the real economic impact of the regulation?
Penn Central looks at the economic impact as a before and after analysis. And that's City of Venice versus Gwynn out of the 2nd District. It looks at what was the property worth in the before condition, i.e. before the law was passed and applied to the property owner.
And Penn Central was the plaintiff in that case given an opportunity to avoid the regulation in its entirety?
The landmark statute at issue in Penn Central, it was basically applied and clear that they couldn't build vertically up over Penn Central Station.
Was there an opportunity to avoid the regulation in Penn Central?
No, there wouldn't have been. I mean,
did they give them 18 months to do something to avoid the regulation there?
No, but a grace period, again, is immaterial. I mean, the law becomes enacted, it becomes applied to the property owner, that there's a grace period. And that's why I keep using the phrase mitigate your damages. I mean, that's in essence what the grace period is. It's we have a law being enacted, we have it applied to the property owner immediately upon enactment. The grace period is in essence just a period by which you, the property owner, have to go to the burden and expense of doing one of two things. Either enclose your citrus, which costs money, substantial amounts of money, or sell it at a fire sale at a reduced price.
And that's counsel. That's why I just very genuinely ask you, why isn't that the economic impact of this regulation, of this statute? The building of the screen room, and then the burden of moving all of your stock into it over 18 months.
Well, it certainly is one economic impact, but again, the economic impact prong looks at the value of the property itself. Again, it's a before and after analysis. But for this regulation, i.e. in the before, what was the property worth after an application, because it is an as applied regulatory takings claim. After the application of the regulation, what is the property worth? And here, after the application of the greenhouse law, the property is in essence commercially unviable.
After the 18-month deadline, anyway, correct?
That's correct. When the Mahons
before the 18-month deadline, not at all. Right? The property's still worth every penny, correct?
The property that they were given a grace period to put to enclose the stock, it did not get rendered commercially invaluable until that January 1, 2008 deadline.
And you agree that had they complied by building the screen room and moving the stock into the screen room, then even after the deadline, the stock would have remained commercially viable, correct?
Again, that's correct. But again, that's taking account circumstances that are not relevant to the regulatory takings calculus. Again, it's not what the owner does or does not do. It's what the government regulations require of that property owner. And here, these property owners testified that they did not envision that someday the Florida legislature would enact a law that said all of their citrus had to be enclosed. I mean, what if this had been a 50
and counsel, it sounds like you're making a very strong argument that the economic impact here is the building of the screen room and moving all the stock in, which seems substantial to me. I don't think that's an insignificant burden, but it seems like that is what you're strongly arguing, that was the burden of the regulation.
Well,
you just said they never imagined they'd have to do that.
It was certainly the burden of the regulation. But that again bears more on the Mahon's reasonable investment-backed expectations than it does the actual economic impact. The economic impact is always to the burdened or the impacted property. It's not on, what the owner could or couldn't have done. It's looking at the property in a before and after analysis. What your honor speaks of is really more relevant to the reasonable investment-backed expectations of the owner, which here the testimony was that neither Mr. and Mrs. Mahon expected that someday they would have to enclose all of their citrus. So again,
at what point, if the statute said in 10 years, forget the 18 months, in 10 years, you have to have all of your stock in a screen room. How does that affect your analysis under Penn?
Well, again, to your honor's point, there is a burden certainly with the time period by which they had to enclose within the 1 year period. You know, if it's a 10-year period, yeah, maybe the burden is arguably less. But I don't think that plays on the economic impact prong. I mean, the impact is at one point, the department.
Because you still have to, because the economic, you still have to build the screen room either way, whether it's 18 months or 10 years.
That's right.
And you still, and literally, I mean, depending on some of the, sounds like there's a lot of stock involved. At least our record seems to indicate that some of these nurseries have an enormous number of trees, right? That can't be easy to move at all once you even build the screen room, correct?
Correct. I mean,
so whether it's 18 months or 10 years, you still have that same economic impact. That's
correct. But for this regulation, the property owner was required to take measures they wouldn't have otherwise been required to take. And again, you know, if this was the case of a 1,000-acre citrus nursery, you know, the burden would be even more substantial to enclose all of that citrus. But again, I think that plays, or I would submit that that plays more into the reasonable investment-backed expectations prong than the actual economic impact prong. I mean, the fact is, citrus nurserymen in Florida didn't.
So you do agree that the 18 months is relevant to Penn Central. You just think it's on the second factor.
I do. Okay. And you know, again, I hesitate to say it's relevant. You know, insofar as, you know, the grace period was offered, I don't think is relevant to the calculus. At some point, the department had a mandate that the citrus that was not enclosed could not be lawfully sold on the market. At that point, the economic impact took effect. So while it's relevant in whether it was a reasonable period of time or not, maybe, but I don't think it's relevant to the economic impact. No.
In other words, look, at the end of the day, you maintain that even giving someone a reasonable amount of time to avoid the regulation is not relevant, does not reduce the economic impact or the takings analysis, really, because essentially, you know, your clients or any other plaintiff should have the ability to ignore that time period, that grace period, that, as you call it, and then bring a takings claim.
That's correct. That's absolutely correct.
And you think that that the takings analysis should be based upon how much the property was worth, as opposed to the economic impact of avoiding the regulation.
That's correct, Your Honor. And again, you know, use of the word avoiding, to me, that's why I use the phrase mitigation of damages. A property owner is not required to do that under a takings analysis.
Maybe the better way to phrase it is compliance.
That's correct. You know, if every owner complied with the law, there would be no takings claim. So again,
not in this case. In other cases, there certainly would be, though.
I'm not sure I follow.
Well, I mean, I don't think every single takings case out there involves a plaintiff who violated the law.
Well, the plaintiff only violated the law.
I'm speaking generally. You can have a takings case. You can have a takings claim without a violation of a law, correct?
That's correct.
Yes,
that's correct. But here again, I mean, using the plaintiff's quote, lack of diligence or lack of compliance with the law is using the very law that we've alleged creates a taking as a reason why the claim fails.
But don't we have to look at the very law that you're alleged creates a taking to decide whether that law is a taking? I mean, don't we have to look at that law? Isn't that what we're looking at? You
would look at the application of it at the point at which the plaintiffs, it became applied to the plaintiffs, and the stock or the property became commercially worthless. I mean, it's at the point, the January 1, 2008 deadline is, but for that law, that nursery stock could have still been sold. And at January 1, 2008, you heard opposing counsel say,
but for is kind of a tort, is often kind of a tort causation way to look at things, right? I mean, if we're going to look at it that way, what's the proximate cause?
Well, but for us, there's still a causation element to.
Well, I mean, but I mean, under that analysis, what's the proximate cause here? Would it be the department or would it be your clients?
The proximate cause is the regulation being passed, and the proximate cause is the application being applied. And here, the application was clear. There was a January 1, 2008 deadline. And at that point, if you had unenclosed nursery stock, it was, in essence, commercially worthless. So I've got very little time remaining. I think I just open it up if there's any other questions for the panel. I think one thing that's critical, the department doesn't challenge the factual findings of the trial judge here. And I do agree with
when you say that, you mean the historical facts, correct? They certainly challenge the trial court's conclusions on the factors.
The department challenges the trial court's application of the facts to the law, to the Penn Central analysis. But really what they've argued here is that the trial court failed to consider two facts, failed to consider the quote heavy regulation of the industry, and I'll rely on my brief for that argument, and the lack of diligence of the Mahons, as I've said, isn't a factor in Penn Central at all. The owner's actions are not the focus of the analysis. And so really the department wants to inject facts that the trial court correctly found were immaterial to the analysis. And so we would argue that the trial court's well-reasoned analysis on the liability of the staking for the 7,700 trees should be upheld. The jury's verdict, and again, I'll rely on the brief for the valuation arguments. The jury's verdict was well supported and should be upheld. And we'd ask that this court affirm the trial court's final judgment in all respects.
Thank you. All right, Mr. Parsons.
Thank you, Your Honor.
There we go.
The importance of this regulation to the survival of the citrus industry in Florida.
Counsel, is there a case anywhere in the country that addresses your opposing counsel's argument, which is that, look, it doesn't matter if the regulation provides a ramp up time or a compliance time, it's a taking nonetheless. Is there any case in there anywhere in the country that addresses sort of that situation?
Yes, Your Honor, I'll give you three. Number one is on the federal level. It's in the federal circuit. It's briefed by us. It's called Meritrans, and it involved new regulations on oil tankers to make them double hold, which would make them safer. And as to some oil tankers, there was a phase-in period. And for those tankers that had a phase-in period.
I recall your discussion of that case. I'll go back and take another look at it. What are the other two that you'd like us to look at?
There's a case from South Carolina and one from Maryland. One of them involved video gaming. There was a phase-in period for poker games and the like, gambling games by video. And the existence of the phase-in period prevented the new regulations from creating a taking. And the other case was a case where there were new emissions standards for motor vehicles. And the existence of the phase-in again precluded a taking from occurring. The phase-in period, as I think both counsel seem to acknowledge, goes certainly to the second factor of reasonable expectations. If you have a phase-in, you can't really expect that if you don't comply with the phase-in, that somehow you're going to be given leniency and you're going to be able to sue the government later for compensation. It probably also goes to the first factor, the economic character, the economic effect on the homeowner, and that you could have avoided, the property owner can avoid completely any economic effect simply by complying with the law. I'd also mention the De Benedictis case by Tuminous Coal Association v. De Benedictis, a case from the United States Supreme Court where they confronted new regulations on coal mining. And it wasn't meant to help people who live near coal mines or who breathe the air from the generation of power from coal. It was meant to benefit the industry itself, make the industry a better place and a more profitable place in the US. And the logic of that case is that when the government imposes a regulation on an industry that's meant to benefit the industry, that's pretty much uniform and can be complied with, there's no taking in that situation. They called it a reciprocity of advantage. That is, everybody enjoys the benefits and everybody enjoys the burden in an industry. And there's no taking under Penn Central in that situation.
Counsel, we only have about a minute left. I'm curious about one thing. You had testified earlier that Inspector Horn was correct when he told the Mahons that they could not do anything with their trees other than destroy them. Why didn't the department just issue the destroy order then?
The record doesn't disclose that. The department always acts by written orders when it is as a formality under Chapter 581 that's required, under the Administrative Procedures Act that's required. Keep in mind the Mahons had already twice had destroyed another batch of trees. These were other trees that had not been destroyed. I expect that a formal written order was going to be in the pipeline if the Mahons did not comply with the law. Regardless of what order was issued, the law on January 1st.
Or you just told this court that there was no way they could comply with the law at that point.
They could destroy the trees, or they could sell to Canada. Yes, the options became very harsh after the deadline.
Okay.
It's just, I suppose, the way the law works, and I would ask this court to reverse on Penn Central grounds. Thank you.
All right. Thank you, counsel. Nice job to both of you. Thank you so much. Have a wonderful day.
Thank you.